Hi, everyone. I'm Judy, the YouTube lawyer. Today I'm here with Remy Oliver, another subscriber
Hello.
who is here ready and willing to help me read a lawsuit that was filed against Harvey and Donna Adelson back in 2016 by their former attorneys. So let's get started. Sorry to be late as usual. And so this was e-filed on September 19th, 2016 in the circuit court for Broward County, Florida. The law firm is called Gerstein and Barrett, PL, Professional Limited Liability Company versus Dr. Harvey Adelson. They misspelled his last name, as you can see. Donna Adelson and American Express Company. Complaint for damages. Comes now plaintiff Gerstein and Barrett, PL, hereinafter GNB, by and through its undersigned counsel, and sues Harvey Adelson, hereinafter individually H.A., Donna Adelson, hereinafter individually D.A., the defendants, hereinafter collectively defendants, and American Express Company, hereinafter Amex, and states the following in support thereof. General allegations.
Plaintiff, GNB is a Florida professional limited liability company with a principal place of business located in and doing business in Broward County, Florida.
Defendants are married individuals who, upon information and belief, are residents of Palm Beach County, Florida.
Amex is a corporation incorporated in the state of New York with its registered agent in New York and with businesses operational throughout the continental United States.
The damages in controversy in this dispute is in excess $15,000, exclusive of interest and costs.
The cause of action accrued in Broward County, Florida, as the contract was made in Broward County. The services were to be performed in Broward County, and payment for services rendered under the contract was to be made in Broward County.
Facts common to all counts. Plaintiff GMB is a professional limited liability company providing legal services, including, but not limited to, representation in criminal matters. Attorney Elan Barrett, hereinafter Barrett, is a partner at GMB.
On or about June 8, 2016, H.A. contacted Barrett regarding representation in connection with a criminal matter in which a subpoena had been served upon H.A.
After a lengthy conversation with defendants, GMB agreed to represent the defendants throughout the criminal investigation for a flat fee of $20,000, which was to be paid in 2 installments. The first installment was to be paid on June 9th, 2016, in the amount of $10,000. The second installment was to be paid on July 9th, 2016, in the amount of $10,000.
Barrett was extremely clear in informing defendants that the case was being accepted on a flat fee basis, which was non-refundable, and that the amount would not be returned to defendants under any circumstances.
The following day, on or about June 9th, 2016, H.A. once again met with Barrett. During that meeting, H.A. authorized a credit charge on his American Express card in the amount of $10,000, the initial installment for representation. H.A. was given a receipt for payment, which he signed.
Having received the first installment payment, Barrett commenced work on the case pursuant to the oral contract for representation in the criminal matter. Barrett spent substantial time and effort providing legal services to defendants between June 9, 2016 and July 9, 2016, pursuant to the contract for representation by G&B.
On or about July 9th, 2016, the date on which the second installment payment was due from defendants, Barrett requested that H.A. return to GMB's office to authorize a charge for the balance of the agreed-upon flat fee.
At that time, H.A. refused to furnish payment as agreed to on or about June 8, 2016, and informed Barrett that he no longer wished to retain his services. H.A. then demanded that GNB refund the first installment of $10,000, which had already been paid on or about June 9th, 2016. On or about July 9th, 2016, the initially $10,000, I guess that's initial $10,000 installment had been approved and had been deposited into GNB's business account.
Barrett, on behalf of GNB, refused to refund the portion of the non-refundable fee that had already been paid, especially in light of the fact that Barrett had already performed substantial legal services in the case.
In response, HA initiated a dispute with American Express Merchant Services, hereinafter AEMS, which resulted in a chargeback of the $10,000 flat fee, which had been paid pursuant to the contract for services entered into on June 8th, 2016.
Count 1, fraud in the inducement against defendants HA and DA. Plaintiff hereby incorporates by reference and specifically realleges paragraphs 1 through 16.
On June 9th, 2016, HA personally authorized a charge of $10,000 on his credit card, which represented the first installment of a $20,000 flat fee for legal services to be provided to defendants regarding an ongoing criminal investigation.
HA was physically present in the offices of GNB at the time the charge was made, and HA specifically authorized the charge. In addition, HA provided identification at the time the charge was made, which conclusively established that he was, in fact, HA.
On June 8th, 2016, prior to making the first installment payment, defendants represented to Barrett that they would pay GNB a non-refundable $20,000 flat fee in order to retain GNB to represent them in the ongoing criminal investigation.
On information and belief, at the time that defendants made this representation regarding payment of the flat fee, defendants knew that they had no intention of paying GNB the full amount of the non-refundable retainer.
Defendants represented that they would pay in hopes of including GNB to perform legal services. Inducing GNB to perform legal services for their benefit in connection with the ongoing criminal investigation, including responding to the subpoena which had been served upon defendants.
GNB acted in reasonable reliance on defendants' promises to pay in undertaking to respond to the subpoena, investigate the charges, and perform legal services on behalf of defendants.
GNB was injured by their reliance, as Barrett, as a representative of GNB, spent a substantial number of hours working on the defendant's case and providing legal representation in the matter.
GNB commenced with providing legal services to defendants immediately upon authorization of the charge to HA's credit card account and continued this diligent work for the next 30 days after authorization of the charge.
HA never disputed that he authorized the charge to his account, nor did he indicate that he wished to terminate the contract with plaintiff at or near the time of the charge to the account.
HA knew that plaintiff was performing legal services on his behalf immediately after authorization of the charge to his account and for the 30 days subsequent to the charge to the account.
Wherefore, plaintiff prays that this court award damages against defendants, including interest, costs, and such other relief as this court may find just.
Count 2, fraud against defendants HA and DA. GNB hereby incorporates by reference and specifically realleges paragraphs 1 through 27.
On June 9th, 2016, HA authorized a charge of $10,000 on his credit card account as the first payment towards a flat fee of $20,000 for legal services to be provided to defendants regarding an ongoing criminal investigation.
HA was physically present in the offices of GNB at the time the charge to his credit card was authorized and provided identification that established that he was, in fact, H.A.
Between June 9th, 2016 and July 9th, 2016, G&B provided legal services to defendants immediately upon authorization of the charges to H.A.'s credit card account and for the next 30 days after authorization of the charge.
H.A. did not dispute that he authorized a $10,000 charge to his account, nor did he indicate that he wished to terminate the contract with G&B at or near the time of the charge to the account or for a month after the charge to the account.
H.A. knew that G&B was providing legal services on behalf of defendants immediately after authorization of the charge to his account and for the 30 days subsequent to the charge to the account.
On information and belief, in early July 2016, H.A. made material misrepresentations to AEMS. Namely, H.A. represented that he did not authorize G&B to charge his account in the amount of $10,000, or that services were not provided by G&B in accordance with the agreement under which the charge was incurred.
Such representations were patently false, as H.A. did personally authorize the charge to his account, and services were provided by G&B under the agreement entered into the defendants by the defendants and G&B.
H.A. knew the representations he made to AEMS were false at the time that the allegations were made.
H.A. intended that AEMS would rely on the misrepresentations and would initiate a chargeback of the $10,000 amount paid to G&B.
AEMS relied on defendants' false representations and did, in fact, initiate a chargeback of the amount paid to G&B.
On July 21st, 2016, G&B received notice that defendants intended to dispute the $10,000 charge, which was made on June 9th, 2016.
In response, on July 27, 2016, G&B made a timely objection to the dispute through the appropriate channels by sending an affidavit and receipt to AEMS.
G&B has been harmed by defendants' misrepresentations to AEMS in that G&B has not been paid for providing legal services to defendants pursuant to the agreement for representation.
Wherefore, G&B prays that this court award damages against Harvey Adelson, interest, costs, and such other relief as this court may find just.
Count 3, breach of contract against defendants H.A. and D.A. Plaintiff hereby incorporates by reference and specifically realleges paragraphs 1 through 42.
G&B, by and through its partner, Barrett, entered into a contract with defendants on June 8, 2016.
Under the contract, G&B promised to provide legal services relating to an ongoing criminal investigation for the benefit of defendants. In exchange for the above stated representation, defendants agreed to pay G&B a non-refundable flat fee in the amount of $20,000, which was to be paid in 2 installments of $10,000 each. The first installment to be paid on June 9th, 2016, and the second installment to be paid on July 9th, 2016.
On June 9, 2016, defendants authorized the first installment payment by way of a charge to H.A.'s American Express credit card account.
G&B then commenced performance under the contract in accordance with the terms of the agreement and provided legal services to defendants.
Defendants materially breached the contract by failing to pay the second installment of $10,000 on its due date of July 9, 2016. Defendants further breached the agreement by fraudulently initiating a chargeback of the first installment in the amount of $10,000.
At no time did G&B fail to render any obligation under the contract.
At the present time, GMB has performed all conditions precedent to bringing this action, and or any such condition precedent has been waived by defendants.
GNB has suffered damages by the breach of the contract because GNB has incurred a chargeback of $10,000 on its account. Further, GNB has not received the second installment of $10,000 pursuant to the agreement for legal services entered into on June 8th, 2016.
Wherefore, the plaintiff prays that this court awarded damages, including compensatory, consequential, and expectancy, interest, costs, and such other relief as this court may find just against defendants.
I'll let you say that title there.
Count 4, quantum meruit against defendants H, A, and DA.
GNB hereby incorporates by reference and specifically realleges paragraphs 1 through 52.
GNB provided legal services to defendants pursuant to a contract which defendants breached.
GNB's legal services included, but were not limited to, investigating the case against defendants, responding to a subpoena served upon the defendants, and protecting the interest of defendants in inquiries from the media and other sources.
Defendants knew and in fact requested that GNB provide these legal services and authorized GNB to provide those legal services.
Defendants knew that GNB expected to be paid for the legal services being rendered in connection with the ongoing criminal investigation. In fact, defendants specifically agreed to pay GNB $20,000 in 2 separate installments as payment for the services rendered.
After GNB expended considerable time and efforts complying with its contractual obligations to defendants, defendants initiated a fraudulent chargeback against the first $10,000 installment paid to GNB.
At the time in which the first installment payment was fraudulently taken from GNB's account, GNB had completed hours of work on the defendant's case pursuant to the contract with defendants. GNB has not been paid or received any benefit from defendants or third parties for its work on the defendant's criminal matter.
GNB reasonably expected to be paid for its services, as defendants specifically agreed to undertake this obligation under the contract for legal services.
It would be inequitable and unjust for defendants to benefit from the performance of legal services without paying for the value of the legal services already rendered.
Wherefore, GNB prays that this court awarded damages, interest, costs, and such other relief as this court may find just against defendants. Count 5, Florida Deceptive Unfair Trade Practices Act, FDUTPA, against defendant MX.
GNB hereby incorporates, by reference, and specifically realleges paragraphs 1 through 63.
On June 9th, 2016, HA, a customer of Amex, made a non-refundable payment by way of American Express credit card to GNB for legal services to be rendered in connection with an ongoing criminal investigation.
The charge, which was made on June 9th, 2016, on information and belief, became final shortly thereafter.
On July 21st, 2016, AEMS sent a dispute notification to GNB, alleging that the $10,000 charge was being disputed by HA as an, quote, unauthorized charge, unquote.
GNB made a timely response to the dispute notification by way of affidavit stating the circumstances surrounding the retention of the funds by GNB, as well as a receipt signed by HA, which specifically states in capital letters, quote, all charges are final. There are no refunds, end quote.
The correspondence was faxed to AEMS by GNB prior to the deadline stated in the notice, which was August 4th, 2016.
However, notwithstanding the sworn affidavit from GNB, an office providing legal services, asserting the charge was in fact authorized, and that services had been rendered in accordance with the agreement, Amex initiated a chargeback of $10,000 against G&B's business account.
The chargeback unilaterally and without regard for the sworn statement put forth by G&B constitutes an unfair trade practice which is highly injurious to consumers.
G&B was relying on the $10,000 deposit, which, on information and belief, had become final for 2 months prior to the chargeback being drawn against their account.
The chargeback necessitated a partner of G&B placing personal funds into the business account of G&B to avoid defaulting on other business obligations.
G&B is damaged in that it has been deprived of $10,000, which was rightfully earned by G&B through providing legal services under a legal services agreement with Amex's customer, HA.
Wherefore, G&B prays that this court awarded damages, interest, costs, and such other relief as this court may find just against defendants. Count 6, negligence per se, against defendant Amex.
G&B hereby incorporates by reference and specifically realleges paragraphs 1 through 74.
On June 9th, 2016, HA paid G&B $10,000 for legal services to be rendered in connection with legal representation in an ongoing criminal investigation.
Payment was made by American Express credit card and was conducted in person in the offices of G&B.
G&B specifically informed HA that the payment was non-refundable, and HA agreed.
On July 21st, 2016, G&B received a notice of dispute from AEMS informing G&B that HA had contested the charges that were made on June 9th, 2016 in the amount of $10,000.
G&B responded with an affidavit denying the dispute as well as a receipt which was signed by HA.
On information and belief, the payment from Amex had become final on or before August 4th, 2016, at the time that a chargeback was initiated against G&B's account.
Once the settlement became final, Amex's right to initiate a chargeback had terminated pursuant to Florida Statute Section 674.1241, Florida Statute Section 674.215, Florida Statute Section 674.2131.
Under Florida Statute 674.2131, a settlement becomes, quote, final, end quote, on a payment with respect to a tender of settlement by credit in an account in a Federal Reserve Bank when the credit is made.
Under Florida Statute Section 674.215, once a settlement becomes final on a charge, there is no right by the bank to charge back on the account of the person who deposited the check.
Under Florida Statute 674.2141, if the charge is not yet final, a bank must exercise ordinary care with respect to a chargeback on an account, or else it becomes liable for damages caused by its failure to act with due care.
Because the settlement on the payment had become final, Amex had no right to charge back the funds, and in doing so specifically violated the provisions of Florida statutes cited above.
In addition, even if Amex did have a right to charge back and/or the charge had not become final, quote unquote final, Amex failed to abide by its statutorily imposed duty to exercise ordinary care with respect to the chargeback as required by Florida Statute 674.2141, because it made a chargeback notwithstanding a dispute from G&B supported by a sworn affidavit which was made by a legal professional and accompanied by a signed receipt indicating a final, non-refundable transaction.
A reasonably prudent bank would have acted differently under the circumstances given the affidavit, receipt, and status of the party against whom the allegations were made.
G&B is in the class of individuals whom the statute is intended to protect.
G&B is suffering the exact injury which the statute was intended to protect against. Namely, it has been charged out of funds which are rightfully entitled to it and which had become final in its account after rendering professional services under a contract.
Amex's violation of Florida statutes, which prohibit chargebacks after payment has become final and only with due care on transactions for which payment has not become final, is the proximate cause of G&B's injury.
Wherefore, G&B prays that this court awarded damages, interest, costs, and such other relief as this court may find just against defendants. Count 7, wrongful debit against Amex.
G&B hereby incorporates by reference and specifically realleges paragraphs 1 through 86.
On June 9th, 2016, H.A. paid G&B $10,000 with an American Express credit card for legal services to be rendered in connection with an ongoing criminal investigation.
On July 21st, 2016, G&B received a dispute notification from AEMS.
G&B made a timely reply with a sworn affidavit denying the existence of a dispute and attaching a receipt which was signed by H.A.
On information and belief, the $10,000 charge had become final at the time that the chargeback was initiated against G&B's business account.
Because the charge had become final, Amex had no legal right or any other authority to charge back the $10,000 against the account.
Initiating the chargeback was wrongful against G&B, and G&B was damaged due to the wrongful acts of Amex.
Wherefore, G&B prays that this court awarded damages, interest, costs, and such other relief as this court may find just against defendants.
Demand for jury trial. That's it. Plaintiff demands trial by jury on all issues so triable under Florida law.
So there you have it. This is a public record. Thank you to the subscriber who emailed me this document. So what do you think, Remy? Any thoughts about this?
Right. I personally didn't know they were, I'm assuming Harvey and Donna were served a subpoena and they were escaping that through using the lawyer, I guess.
Yeah, or they wanted some sort of guidance on what to do. And I'm kind of surprised also, that they would hire this small law firm that seems to really market itself more as an immigration law firm.
Right.
That attorney, Elan Barrett, graduated from St. Thomas Law School, and I think he's originally from Israel.
Okay.
So this is the website. They have a really nice website here, but it's, as a small business owner myself, I know how devastating it is when you do all this work for clients and then months later or a month later, then they try to dispute the charge or they try to demand a refund or partial refund. It's just horrible to treat small businesses like this, especially when the attorney made it clear this is a non-refundable flat fee.
Right. So I wonder what the resolution or the outcome was of all this.
Oh, well, the good news is that this case resolved, I would say, within just a few months. I think it was around December 5th of 2016 that the case was voluntarily dismissed, which makes me think that they must have gotten their money and gotten a settlement pretty quickly after filing the lawsuit. So this is that poor guy that they tried to screw over, allegedly. Okay, it says Elan Barrett, a partner in the law firm, has been practicing law since 1999. He's a member of the Florida and New York state bars and the Israeli bar. He's also been admitted to the U.S. federal court for the Southern District of Florida. He's a member of the American Immigration Lawyers Association and the ABA. He got an LLB from Manchester University of England and his JD from St. Thomas University. and he served the U.S. Coast Guard Select Reserve in their legal department in Miami. He is fluent in Hebrew. Thank you so much for your time and everything, and we'll definitely be in touch.
Awesome. Have a good one, everyone. Thank you.
Okay, thank you, everybody out there. Thanks for joining in. Have a good weekend.
Bye-bye.